This is Jason Saville at the Boulder County Jail in Boulder, Colorado. It's a beautiful day in June, and I'm about to go visit a client, somebody brand new. Issues today are getting him out on bond. This is a domestic violence style case. Therefore, he has to see a judge before he can be released on bond, because he has to agree to the protection order in front of the judge. What is the protection order? It typically means you have to stay away from the house. The person that is involved in domestic violence, meaning the complaining witness or alleged victim. So the suspect has to stay away from the alleged victim or complaining witness. They have to stay away from the house. If it's a shared house, have to move out. They can get a civil assist. A civil assist is a sheriff's deputy that shows up and spends about 10 minutes with you while you gather a few things so that you can survive. This is not moving out. This is not packing everything. This is just stuff. That's a civil assist. You contact the sheriff for that. Bond today is going to be determined by the bond commissioners. When you're in the jail, they interview you and ask you questions about what that is about your prior history, your work history, your connections to the area, family, other people that can help you make it back to court. The idea is to get you back to court. There are also some other issues like danger to the community and that sort of thing. For most first-time domestic violence charges, misdemeanors anyway, a person will get a PR bond. PR means personal recognizance. That means that you're going to get out simply by signing your name. It doesn't mean you don't have conditions. You probably have some kind of drug or alcohol condition where you're getting tested. You will probably have some kind of monitored sobriety so that and monitored release so that you stay out of the out of trouble, basically, is what they're asking you to do. So these are issues today. Although the court happens around 1:30 in the afternoon, and you might get a bond by 3 that says all you need to do is sign your name, and you've signed your name, well, they're probably not going to have you out of jail until 6 or 7 o'clock at night. But you can be released. That's better than staying in. Baked brie. I came across this in law school. A friend of mine had it at every party. I basically planted myself next to the baked brie and ate all of it. I really appreciate those parties. I missed them. So basically, you get some Pillsbury crescent roll dough, and you get a roll of brie, a round one. You spread out the crescent rolls in a star shape, like this photograph, and then you put the round brie right in the middle of it, and you fold those up, like in this photo, and make your little design if you wish. Sometimes you end up with an extra crescent roll. You can make that into something. Bake it exactly how the package for the Pillsbury crescent rolls says to bake it. What you're wanting is that the brie does get soft and warm in the middle, but not too cooked. And you don't want the crescent rolls to burn. And if you're finding that you're burning your crescent rolls and the middle is not quite as warm as you'd like, then reduce the heat and increase the time. That should allow the metal to get cooked without the outside getting burned. If there are priors, if there is a serious injury, if there's not sufficient ties to the community, your bond can be higher. You might have to pay to get out. Typically a bond in this county will have a cash option. The cash option is typically 10% of the total bond. So if you were given a $1,000 bond, you pay $100 in cash and you get released, you would get that money back. You don't have to go through a bondsman. You can thank your Colorado Criminal Defense Bar for that legislation and for the public defenders. They helped us lobby that. The entire defense community worked on that. Makes it cheaper to get out and you get your money back. Problem is that there is a fair amount of supervision now, and even for people that probably don't need it. Main thing with the protection order to know is that if there is any contact by you, by your friends, text, email, phone, in person, sending a birthday card, whatever, that can be a violation of the protection order, which will add additional charges, both violation of protection order and a violation of bail bonds charge, which has on a misdemeanor a 6-month minimum mandatory jail sentence, and on a felony it's a 1-year mandatory jail sentence on a felony charge. So very important that you understand your bond conditions and your protection order and that you don't violate it. It's up to the judge. It's not up to the complaining witness or alleged victim. The complaining witness or alleged victim cannot change it unilaterally. The only person that can change it is the judge. So if you don't want to spend less time in this place, more time in the world out here, then understand your bond conditions, work with your attorney, try to have stay away from the person, and trust that things will work out as long as you listen to the people that know what's going on.